Hi, my name's Christopher Carr. I'm a family law attorney here in Clark County, Las Vegas, Nevada, and I'm creating a series of videos to help people understand the court system here and family law in Nevada. So today's video is going to be about motions. If you've watched my other video, and if not, I encourage you to do it. If you've watched my video on how the court system is structured and how your case moves through it, then you may recall that I mention motions, but I don't get into a lot of specifics about it. And that's because motions are very common, they're very useful, and they're very important tools in the family court, but they're not something that are utilized in every case. So I didn't get into it in a lot of detail. Well, today's the day for that. Now, also, as with all my videos, I need to, of course, remind you that this is general legal information. Just to give you an overview of the court process here. Nothing in this video should be construed as legal advice, and nothing beats sitting down with an attorney and talking about the specific facts of your case and how the law applies in your situation. So you really need to do that. But in motions in particular, you need to be very careful, because if the judge feels when you're in court and he's addressing your motion, if he feels that your requests were inappropriate or worse yet, harassing to the other party, the judge could actually order you to have to pay the other party's attorney's fees. So it can be financially burdensome if you file a motion and end up losing it. That's why with motions in particular, you should at least discuss with an attorney, even briefly, your situation, what you're looking for, and if the attorney feels that you're actually entitled to that, or if he thinks it might be a big mistake for you to request what it is that you want. So, what do we request with motions? Well, the sky's really the limit with motions. They are documents that can be filed at the beginning of the case, middle of the case, or even after the decree of divorce or custody, final custody orders are made. They can really be filed at any time. So I'll give you some common examples. When you first file for divorce, you may be concerned that my husband will throw me out of the house, he will cut me off financially, he will keep the kids away from me. What do? I need a divorce, but I'm worried about all these things. Well, you could file a motion and ask for exclusive possession of the residence. That would force your spouse to leave. For temporary custody orders, so the children know where they're supposed to be and when, and who's supporting them for that matter. And you could ask for temporary spousal support. If your other party was the one that made all the money during the marriage, and you're concerned that you're going to be cut out financially now, you may want to request temporary spousal. You could also request preliminary attorney's fees. In Clark County, the judges are very serious about parties being able to each be adequately and equivalently represented in court. They don't like a situation where one party is in there unrepresented because they can't afford an attorney, and the other party has the money, has a lawyer, and just kind of runs over the other party that can't afford the attorney. So they will allow some shifting of the attorney's fees around so that, as the court puts it, you can be in there on equal footing. So just a couple of examples of when you may want a motion. Now, you may have gone through the whole process already. You may have a decree of divorce. You may have a custody decree. You may have final orders of annulment or separate maintenance, or you may have gotten exactly what you originally came to court for, and then you find out that something got left out, something was forgotten, or something's changed and it needs to be addressed. So although you're done, you may decide that, hey, my ex-spouse got married, or I've lost my job. I can no longer afford to pay the spousal support that I was ordered in the decree, so I'm going to file a motion for an adjustment of the spousal support. So the judge could then look at your situation again and make a different decision about your alimony. Or with children, there's a tremendous opportunity to return to court for several years. If you happen to have a divorce or custody orders from the time that the children are very young, remember that you're going to be tied to that other parent for up to 18 years until that child reaches the age of majority. So you may move across town. That may complicate your custody and visitation orders. You may have medical bills that the other party's not paying. You may want to relocate out of state. Or maybe the other parent begins to do things that are not in the best interest of the child, and you need the custody orders that were made to be adjusted somehow. Again, these are all situations where a motion may be appropriate. Again, you need to discuss that with an attorney to make sure that the facts in your case actually warrant the motion and that the law supports what it is you're trying to do. So now that you've decided you want a motion and that it's appropriate to file one, how does it work? Well, you go to the courthouse and you file your motion with Master Calendar. That's the department at the court that assigns all the court dates for the judges. So you'll get your motion from Master Calendar with a court date on it. You then electronically file it so that it becomes part of the judge's record. And then you need to serve it on the other party. If it's at the beginning of the case and the other party hasn't been served at all, you'll need to serve that with all the other documents that you're filing at the beginning of the case. If it's a case that's already been served personally on the other party, you can generally get away with mailing your motion to the address of record with the court and providing some proof of that mailing to the court. I would recommend, if you're representing yourself, that you get a return receipt requested or some other documentation from the post office showing that the documents were actually delivered. So once those documents are delivered to the other party, that party then has 10 days to respond. And the response is done by what's called an opposition. It opposes the facts and the relief that are requested in the initial motion. That's the motion you filed. When a party files an opposition, very often they also file what's called a countermotion. That's that party's own version of events, their own perspective on the facts, and their own request for relief. So that then must be served back to the party that filed the motion. Once the opposition and counter motion are received by the first party, that party is then entitled to do a reply. That's sort of one last shot here to clear things up that are raised in the opposition and counter motion and present everything to the judge again. Now, as I said, motions filed, other party has 10 days to file a response. Once that opposition and counter motion are received, you must, if you're going to do a reply, you need to file that 5 days before the court date. And we don't count weekends and holidays when we calculate this. So basically, you're filing your reply a week before the court date. So once all that's filed, it's going to be part of the court record. The judge will see all of that, provided that it's filed quickly enough that it goes through the electronic filing process and is available to the judge when he's reviewing for court. And that's what the judge will actually do before the date of your hearing. So when you come to the date of your hearing, I recommend that you get to the courthouse at least 15 minutes early, check in with the marshal at the courtroom, let the marshal know if you're expecting an attorney to be with you that day so that the marshal knows when everybody's present. When all the parties are present and the judge is ready to see you, the marshal will call you in. Now, most of the time, the judge has read everything and is very familiar with the facts in your case and familiar with what's going on in your situation. So it may not be necessary to say a lot. The judge may not want to hear really anything and may almost be ready to make a decision. Other judges will want you to review the information that's contained in your court documents again, but the judge will more or less let you know what she's expecting that day. And at the conclusion of the hearing, the judge will make his or her decision. So for a temporary situation, such as you'd have at the beginning of a divorce case, the judge will make temporary spousal support, child support, and child custody orders, if that's what you're seeking in your motion. These are not going to be permanent orders. They're not going to be the kind of thing that stay in place permanently. At the beginning of the case, the motion is used only really as a band-aid to get parties to the trial. If you watch my other video, you know that it can take 4 to 6 months from the time that the case is filed until you're actually in court on your contested issues. Well, some things just can't wait that long, and that's when you may want to do a motion, and the judge will make temporary orders to get you through to the trial. But then at trial, you have to prove your case. So if you're alleging that the other party is an inappropriate person to have joint custody and that you should have primary, you may well get that as a temporary order of the court. But when you get to trial, you're still going to have to prove your case. Otherwise, the judge could shift it back again. So if there are issues that cannot be decided, and most issues that are significant, such as changing custody or setting support when parties have totally different sets of facts about who makes what, those are the kind of matters that are going to only be finally resolved at a trial. So you may get your temporary orders, but still have to wait for some permanent outcome. But again, motions are the only way to get that temporary relief and get some temporary safety net in place. So that's motions, oppositions, counter motions, and replies. Again, these are very useful tools in some situations. They're very necessary tools in some situations. It may be the only way that one party or the family can really survive from the filing of a divorce until the final trial, or the filing of a custody action until the custody trial. So don't forget that's out there, but also don't just walk into that unprepared and uneducated in your case, because the worst thing you can do is file a motion to try and get help on something, and for some reason make an error or some other inappropriate action, which instead of getting you some relief ends up costing you thousands of dollars in the other party's attorney's fees. So again, very important that you discuss the facts of your case and the law with an attorney so that you can get an understanding as to whether what you're seeking is even allowed by law, whether it's appropriate, whether the facts of your case support such a decision, and whether the law is there to support you too. So please talk to an attorney. My office is more than happy to discuss your case with you and give you a consultation about how your facts work into the court case and how the law applies in your situation. Please give me a call at 702-425-6301, or you can find me on the web at www.lvdivorce.com. That's LV like Las Vegas, divorce.com. Thank you.